Okay, but so pushing back into appeal can be a really valuable thing. That this business of being able to push it in without having to pay any additional appeal fees. When I started at this job about 4 years ago, one of my first assignments was to act as kind of a consultant for one of our customers to go through their portfolio and see if there was anything strange or unusual going on. And the thing that immediately jumped out at me were the number of cases that were being pushed back or that were being pulled out of appeal. So I kind of looked into that, and I realized that some of them were being pushed back into appeal years and years later, and they were paying the fees again. And that's when I discovered another very useful provision, which is that you can get that money back. So that's definitely something to look into in your portfolio, kind of an easy money save there. If you ever had a case that was pushed back into prosecution and then went back into appeal and you overpaid, you should be able to get that back. And this applies even if you push the case back into appeal years later. Like, there's no time limit on this. It could have gotten pulled out of appeal 5 years ago, and just now you're thinking, hey, I want to push it back into appeal. You don't have to pay those fees. Well, certainly if the cost had increased, you'd have to pay the additional cost, but you wouldn't. Whatever you had already paid would go towards the appeal fees. So when does it make sense to do this? Of course, you should consider the examiner's ETA and allowance rate. How difficult is prosecution with that examiner? And you should also consider what's the outcome for cases that actually make it all the way to the board. And again, I mentioned this earlier, but notice if it's a cycle, if it's a habit for the examiner. Because examiners who don't want the case to go all the way to the board, it might be because they just simply don't want the board to be looking over their shoulder. And so that could be something for you to leverage during prosecution. And this is just an example of an examiner who, in a situation where you probably want to push the application back into prosecution back to the board, because the examiner's ETA is very high, 11.1, solidly in the red zone. But your chances of winning on appeal are basically a coin toss. And personally, I would take a coin toss over an examiner whose ETA is 11.1.